Getting Your Super Right. Legal by Melisa Sloan.
For many of us, superannuation is that little bucket that sits in the corner that you give little thought to, aside from the prospect that one day, when you reach retirement age, you may access it for your retirement years. The reality is that superannuation is much more than that. It is likely to grow to be one of your biggest assets, and it's imperative that you understand superannuation so that you can make some prudent decisions that have implications for you and your family's future.
You need to put a nomination in place.
There is a misconception that your superannuation is part of your will. It is not. Superannuation is an asset that is held in trust for you by the trustee of your superannuation fund, and as such, you need to provide a direction to the trustee of your superannuation in respect to where you would like your superannuation to be paid at the time of your death.
Types of nominations.
There are a number of different nominations that you can put in place. These include binding death nomination. This is a binding nomination directing the trustee where you would like your superannuation to be paid at the time of your death. Often these nominations need to be reviewed and renewed every 3 years, or they lapse. Non-binding death nomination. This is a direction to the trustee where you would like your superannuation to be paid at the time of your death. However, it is not binding on the trustee. Non-lapsing binding death nomination is a binding nomination directing the trustee where you would like your superannuation to be paid at the time of your death. This type of nomination is non-lapsing and does not need to be renewed or reviewed every 3 years. It will remain in place until such time that you revoke such a nomination or change such a nomination. It is essential that, if you elect to put a binding death nomination in place, you verify whether it requires review and renewal every 3 years. If it lapses, it is deemed that you do not have a nomination in place.
How do I put a nomination in place?
Most superannuation funds have the relevant nomination forms on their websites for you to print out and complete, and subsequently submit the completed form to your superannuation fund. If you have a financial advisor who looks after your superannuation, they will be able to assist you in putting a nomination in place. Should you not have any nomination in place, it is up to the discretion of the trustee of your superannuation fund to determine who will receive your superannuation. The superannuation fund's trust deed will direct the trustees as to where your superannuation can be paid.
Who can receive my superannuation?
This is where it gets tricky. Most people think they can leave their superannuation to whoever they choose. However, the superannuation laws stipulate that there are certain people to whom you can leave your superannuation, and these people are referred to as dependents. Dependents for superannuation purposes are a spouse or a partner, children, someone who is financially dependent on you, and someone you are in an interdependent relationship with, someone you have a close personal relationship with, and one or both provide care, domestic and/or financial support. If you do not have any dependents, then you may leave your superannuation to your legal personal representative, also known as your executor, and your superannuation may then be distributed in accordance with the provisions of your will.
Beware of tax implications.
It is important to be aware of the tax implications when nominating a beneficiary to receive your superannuation. Superannuation dependents and tax dependents are two different things. By way of example, a spouse is deemed a dependent for both superannuation and tax purposes, so any superannuation that you leave your spouse at the time of your death will not be taxed. However, whilst an adult child is deemed a superannuation dependent, they are not deemed a tax dependent, so any superannuation paid to them is likely to be taxed. It is therefore imperative that you understand the composition of your superannuation and the taxable and non-taxable components so that you are aware of any tax payable at the time your superannuation death benefits passes to your beneficiaries. Obtaining the appropriate financial, accounting and legal advice can equip you to make informed decisions that could save you and your family considerable tax savings and ensure that your nomination fits holistically within your estate plan. Give superannuation the attention it deserves. Equip yourself with the relevant information and ensure your nomination documents are in place, protecting your and your family's future.
The content of this article is of a general nature only, and you should seek the appropriate advice for your own situation. Melisa Sloan is an estate planning lawyer at Madison Sloan Lawyers in Park Orchards. For more information, visit madisonsloanlawyers.com.au. This article was read by Rebecca Rose.
Sandy Miller.